Alex Harp. She's the clerk for Judge Fox.
Okay, and did you say that Judge Fox was helpful?
Yeah.
Like particularly helpful to the interns and stuff like that?
Mm-hmm.
Okay.
She's very into mentoring and
okay.
Same with Judge Arroyo. That's like both are really.
Okay, good. So a couple of you have mentioned that. All right. That is great. All right. Good stuff. And then I'm going to talk again to Judge Carparelli, who, when I taught this course 3 years ago, he came over and was great. And then maybe Justice Marquez, because she's one of the people who actually really wanted you to have this class. So.
And Julie Nichols is clerking for Carparelli. So
oh, that's perfect. Oh, that's great.
For when you're emailing.
That's actually great to hear, because one of my students in that class in 2010 was going to be his law clerk, and I was hoping, that
it worked out.
Impression. Excellent, excellent, excellent. Okay, great. Okay, so I want to talk about the article presentations, and again, everything we do in this class, it's really about you guys and providing a good experience for you. So I'm pretty flexible with how we approach that, and also the timing, so we'll talk about that a little bit. And then I just want to kind of look at what we've done so far and why we're doing what we're doing in the class and where we're going forward from here. And then we have ethical judicial opinion writing to discuss, and then also we'll spend a little bit of time on Plessy versus Ferguson, and if we have time, on Bowers versus Hardwick. Our conversations tend to go very well in this class, so I don't always necessarily get through everything on the agenda. But first on the article presentations, basically what I want for these is for everyone to read the articles, but then the person who's assigned to the article is sort of the expert on the article, right? And that means two things. That basically I would like for you to run the class for about 20 minutes, and some combination, you can decide how you want to do it, but some combination of you presenting the article, so giving a little mini lecture, but also creating discussion questions. If you want to do a little writing assignment or a quiz would be, especially wonderful. Whatever you want to do with that 20 minutes to get the classes engaged, including me, as engaged as possible in talking about the article, okay? The idea behind that is just to give you, when you're teaching other people, you really get into the material in a way that's different. And so the article that you chose that presumably you're interested in, you really get to be an expert in that and carry that sort of perspective with you into your clerkship. So I think that'll be a valuable experience. So the question really is timing, and whether someone named Alexis wants to volunteer to be sort of the sacrificial lamb who goes on Wednesday.
Sure.
While the rest of the group goes on Monday. Now, if you think that's unfair, I shouldn't put you on the spot like this, but if you feel like that's not feasible,
no, that's fine.
Okay.
Can it be like elementary school, or if you go first, you get extra credit?
Yeah. Okay. Extra credit.
Wait, so then everybody else gets to go on Monday?
Yes.
Okay.
A little unfair. It's a little unfair. But again, it's not it's not a competition or anything like that. But I just think that your article is probably the best sort of foundational article. And then Bill, I was hoping to move on Monday to have you be next up. And then, Will, tell me, you wrote to me, but tell me again.
Yeah, I was doing the rational judicial study.
Good, okay.
Did you say in your email which article each person has?
No. Okay, so the most important one for Wednesday is Alexis's, which is the art of legal reasoning.
Okay.
So then let's have, and maybe I'll just keep talking on Wednesday and we won't get to it. It's up to everybody now.
It's totally fine.
And so then Bill, you'll be second up. Will third.
Which one is yours?
I have formalism, realism, or formalism,
It's like the new realism and new formalism. And this whole sort of realism-formalism debate is kind of one of the core issues in judicial behavior, so that I think will be helpful. Then Will, and then Kira, and then Allison?
All on Wednesday, or I'm sorry, all on Monday?
Yeah, all on Monday. So 20 minutes each, we should be able to pull that off in the time that we have. Does that work for everybody? Do you have any questions about kind of, presenting an article or what that means?
Will you just tell us which ones you guys have?
So since there's 4 on Monday, I mean, as far as how detailed we're supposed to be reading the articles for other people's,
Judicial behavior.
Generally, kind of not too in-depth, but
So, no, that's good.
Kind of a lot of reading.
It is a lot of reading. It's true, it's true. And that part of the idea of the presentation is to spread the work around a little bit, right? So let me ask you guys. So if you had to lead a discussion on your article, what level of depth, would you want people to read your article at? I mean, what would you say is the goal for them in terms of reading the article? So we're not trying to get every single detail, but...
Yeah, I think being able to talk about it, but I wouldn't expect them to know kind of really small details or...
Okay. So obviously you want to look at the subject matter. The sort of the thesis is obviously important. The sort of arc of the argument. And maybe if you have a critique of one or more parts of it, okay? But yeah, I mean, I think I'm not editing any of the materials for this class. I'm just kind of throwing it all out you guys so you can develop that capacity to sort of get at the heart of, what you want. And I do close readings of Supreme Court opinions now, but I haven't really read an article kind of word for word in a really long time. I think it just depends on what you're going in it for, but we should all be competent to discuss the articles, at that sort of level. Okay. Any other questions about that?
Should we read the other? Are they related enough to kind of tie into each other or overlap, or are we just doing our own presentation?
So you're going to read them all because you're going to discuss them, right? When the other people present. I mean, they all overlap in that they are trying to sort of set out a model for judicial behavior, either describing judicial behavior or setting out sort of an aspirational model for judicial behavior. Okay. But they're pretty distinct topics within that. Okay? All right, cool. And if you have questions about it in the meantime, Alexis is going to go first and sort of set the standard for all of us. So that will probably give us a chance to talk about the process a little bit more. Okay, so in terms of where we're at, where we've been, where we're going, first of all, remember we all have, Alice, I think we're meeting after class today, and the rest of you have meetings with me on Wednesday to talk about your PT, and that's really just a chance for you to vent a little bit about that process and for me to get to know you a little bit more on an individual level and start talking about what you particularly want to get out of the class in terms of your writing and analytical skills. And the idea, this is a little unusual for me to start a course this way, but I really wanted to talk about these sort of ethical issues and the judicial behavior issues as a foundation before we jumped in the problem. So that's really kind of what we're doing now, wrapping up with you guys, presenting the articles on judicial behavior, and that's really supposed to be sort of a background, right, to the work that we're going to do going forward, because as of, what is it, the 6th? Yeah. We are going to get into the problem, and it's kind of going to be a 2-track set of subjects that we're looking at. On the one hand, we're going to look at sort of general issues of procedure, appellate procedure for the Colorado courts, federal appellate procedure for the 7th Circuit, and also just the rules of procedure that will affect you at the district court level, and then pair that with, or sort of understand that in the context of reviewing the progression of the case in the Proposition 8 litigation, okay? Which obviously there was a lengthy district court opinion in that case, which we're going to talk about the function of that. Appellate court opinion, now it's going up or it is in front of the Supreme Court. And in fact, the first brief was actually already filed in that. So the problem is really going to take over the class, right? We're going to be talking about the problem and the primary materials that we're looking at. You all are going to decide, conferring with me as you would with the judge, but you're going to decide what path you want to take through this equal protection analysis in the Proposition 8 case. And there's not a million options, but there are many options. in terms of how you could approach it, right? So that's something that we're going to confer about. We're going to try to help you guys focus because you really can't address every single issue in the context of writing a paper for this class. And what we'll be doing during that time is having group discussions of the case materials and group discussions about the process of judicial opinion writing, and then individual conferences where, you know, I will work with you through the different stages. So first you're going to sort of present an outline that suggests a route through the analysis, and then work on successive drafts and meet with me about that, okay? And then the idea with having just the guest speakers towards the end is that there's not a lot of class prep for you guys, right? I mean, really, after these presentations, it's going to be me sort of giving you materials and instructing you on that, and then you engage in the writing process, okay? So with the judges and the law clerks coming to class, you're certainly going to learn a lot. It's probably going to be some of the most valuable insight that you get prior to clerking, but all you need to do is come to class and ask some questions and be prepared to talk with them, okay? So any questions about that sort of trajectory for us going forward? Okay. So
I have
let's,
one question.
yes, please.
So we don't all have to choose the same
I
structure
would be
for our
shocked
opinions?
if you did.
Okay, that's
Yeah.
okay, great.
And we could talk now if you want to about the, let's just talk about it briefly, just as a little preview, because I know it's a little frustrating sometimes when you're not, you know, you don't have the problem in front of you yet. So the question is, you know, does Proposition 8 violate the federal Equal Protection Clause? Okay, and so Proposition 8, can someone describe sort of what that does, which you don't necessarily, there's no reason you would necessarily know unless you've been following it in the news, but how that worked. Okay, so what happened was the plaintiffs on the state court level challenged, basically California had a dual system where you have, you know, marriage for opposite-sex couples, and then you have civil unions or domestic partnerships for same-sex couples, right? And so this was challenged at the state court level under the California Constitution. And ultimately what happened is the California Supreme Court said, you know, under the California Constitution, same-sex couples have to be permitted to marry, okay? And so that was the state of the law for a period of months. Same-sex couples started to get married, and then there was an election that included this Proposition 8, and Proposition 8 essentially revoked the judicially conferred right to marriage, okay? And of course, then Proposition 8 was challenged first at the state court level, and then in the federal courts. And it's interesting because the state court decision, even though the court was not in a position to invalidate Proposition 8, actually played a critical role, has played a critical role in the federal litigation. Any ideas why that's the case? No, you're kind of thinking about it in the abstract, but what do state courts have to offer in terms of deciding issues in federal litigation? Go ahead, Bill.
They certify a question to them or something? Or
So there was a certified question on the issue of, do you remember? Standing. Okay, so that was actually certified. But prior to even the federal litigation starting up, the state court did something very important. Something that state
They
courts are
interpreted the
particularly good
federal
at.
constitution or their own constitution?
They interpreted their own constitution, but they also interpreted the effect of Proposition 8, which is a state law. Okay?
On the federal constitution or on the state constitution?
The effect, not in terms of either constitution, but the effect in terms of its social impact, really, its effect in reality, okay? So Proposition 8 functions to do X, Y, and Z. It doesn't do A, B, and C. And, you know, those were, so first of all, they're binding as a state court interpretation of its of state law, and they're findings of fact. Why is that important?
Standard of review.
Standard of review, okay? All about the standard of review. And this is also true, a very interesting kind of controversial approach by the federal district court was to put a lot into the findings of fact. There's even some controversy as to whether those findings of fact were actually findings of fact. So this is the same problem you had with Colorado's Amendment 2. When the populace votes to amend the Constitution, it's then, you're sort of precluded from making the argument that it violates another provision of the Constitution, okay? So the state court argument was a procedural argument. That and I'm not an expert in the state court litigation by any means, but essentially that the mechanism by which Proposition 8 was enacted and the change that it affected on the state constitution was sort of procedurally invalid. And the state Supreme Court rejected that argument, okay? But in the context of reaching that decision, it, in very sort of detailed fashion, described the actual impact of Proposition 8, yeah.
I'm a little confused. Are they totally parallel litigation? Like it was filed?
They're sequential. They're sequential.
So it went state to federal?
Yeah, and and I'm not also super familiar with the litigation strategy and the discussion with between the different advocacy groups, but generally, depending on the state, certain impact litigation the advocates prefer to bring in state court because there's possibility for more liberal interpretation than there is maybe if you're not happy with the composition of the United States Supreme Court, depending on your viewpoint. If there's a bad decision, it only affects that state. So your first option, oftentimes, assuming that all the advocates are coordinating on this, is to go through the state courts and try to obtain a victory on that level. And there's another piece of this too, which is that this tension, right, between both the tension between judiciary and legislative branches, and the tension between the federal judiciary and the state, both judiciary and legislative branches. So that, and Bill Eskridge talks about this, not in the piece that you looked at, but in a different article about the idea of the states being a laboratory of experimentation, right? So you want states democratically, through popular election, through legislation, through court battles, to decide controversial social issues before punting it up to the federal government. If you think the issue you're advocating for is actually going to develop in a positive way at the state level, it's much more legitimate for the United States Supreme Court to come in and make a decision vis-a-vis individual rights if those rights have been recognized in the states. So there's a number of different theories why, reasons why advocates would tend to prefer state court litigation first. So after this was concluded, then these attorneys decided to pursue this in the federal court, and there were many people in the gay rights movement who were really uncomfortable with this because they were comfortable with the composition of the court. So, and I saw your hand, Alexis. I don't mean to not answer, but go ahead, Bill, if you want to finish.
So then they filed a completely new action in the federal court.
Different claim.
So
right, because it's a claim now under the federal Constitution, the Federal Equal Protection Clause. So it's a new challenge.
So why are they bound to any findings of fact if it's a completely new claim?
Mm-hmm. So they're not. It's different. Well, there's sort of the two levels on which this is operating. Okay. One level is the Federal Court of Appeals, United States Supreme Court level. So there is the standard of review issue. So the Federal District Court will make findings of fact, and unless those are clearly erroneous, not supported by the record, those are going to be affirmed at the appellate level. The way in which the state court interpretation of state laws is binding on the federal courts is not as a function of appellate review or the standard of review. It's a function of deference to the state court and its unique position to interpret those state laws. So that's a good question. Those two things, in both cases, there's a sort of deference to the specialized function of the particular court, but it works differently as between levels of appellate review in the federal courts and then state versus federal courts. Yeah, Alexis.
So if they interpreted the real effect, right?
Mm-hmm.
And then they go to federal court to challenge it under the Constitution, Are they, but it still has to be a constitutional claim for it to be in federal court.
Absolutely, absolutely.
So are they challenging the interpretation of the actual effect, or?
Well, they can't really challenge it, again, because the state Supreme Court's interpretation of the effect of the law is sort of settled, right? It's a settled matter. Let me talk
Unless
about
their interpretation's unconstitutional under the federal constitution.
But it's a factual, it's not a legal interpretation. It's a factual,
A fact,
it's
so it's
a
an
finding of
as
fact,
applied
essentially.
to those. Okay,
Okay?
okay.
So what happens is then, okay, so you have this background of Proposition 8 being essentially a law popularly enacted to take away a right that had been granted by the judiciary.
I have one more question.
You're never going to go on Wednesday, Alexis, so you're good.
Okay, so if it's a popularly elected, it's an initiative that voters pass, amends the Constitution, so it didn't go through the legislature. Wouldn't the legislature be, like, the legislative history of it be what they would be looking at for, like, the fact finding? Or no? And that the court is just fact finder in that scenario because there is no legislative history?
Okay. So, no, this is all good stuff. This is going to come up in the course of our discussion. So basically, right, so you have Proposition 8, right, the four corners of the document. And so you have, you know, a facial challenge, essentially saying, you know, as it is written, this violates the Equal Protection Clause, right? Yeah, this is actually a great question. Purpose and effect are two different conceptual categories here. Okay, and the way they actually play out in equal protection jurisprudence is somewhat contested. Okay, the purpose of the law you would discern from the legislative history, right? Well, you would discern from the text to some extent and from the legislative history. Now, so this is one way in which the DOMA litigation is different than the Prop 8 litigation. The Federal Defense of Marriage Act, which is also before the Supreme Court right now, basically you had members of Congress sitting down, and I think there's maybe one day of a transcript of proceedings of the legislative history behind DOMA. And they say, you know, we want a uniform definition of marriage, we want to preserve marriage as a heterosexual institution. You know, they give legislative findings in support of that, okay? So that's kind of a more clear-cut situation. When you have a popular initiative, as with Proposition 8 and as with Colorado's Amendment 2, which was the law at issue in Romer versus Evans, you don't have this, right? What do you have? What do you have?
The text of the vote, like whatever was on the ballot?
Yep, you have whatever's on the ballot. What else?
The book explanation of it?
Sorry?
The, like, what is?
Yeah, no, that's a good point. I don't know if they had that in California for this, but you might have, though, what's that a process of, or product of?
Information from the people lobbying to get it on the ballot or people opposing it being on the ballot?
As I understand how it works in Colorado, both of those groups have to come together to craft the description, which is why it's so unintelligible. Right? It's drafted by committee. What else? What else? If you want to say, well, this is the meaning of this particular law that was popularly enacted, what else might you point to as evidence? This also goes right to the heart of my article, which is, it's very exciting that you guys are talking about this. What else? This is what people meant when they enacted this law. This is what they were voting for.
It's like advertising?
The campaign literature, right? Okay. So that is a possible place to look. Now, what's interesting is that the courts did look at this in the Prop 8 litigation, both the Federal District Court and the Ninth Circuit Court of Appeals. In Romer versus Evans, looking at Amendment 2, there's nowhere to be found. They did not discuss the campaign literature, okay, for reasons that we can discuss later on. What Romer did is it focused on the sort of so-called objective effects of the law, okay, and this is same thing in Romer. The United States Supreme Court says, well, the Colorado Supreme Court, in interpreting the effect of Romer, because Amendment 2 also went through the state court before it went to the federal courts, defined the effects this way. Okay, so now, you can't advance this type of discrimination claim based on sexual orientation. You may not be able to advance a constitutional claim based on sexual orientation, etc. Okay, so the essence of equal protection analysis at this point in time is two-part. First, to determine what level of scrutiny applies. Right? Does that ring a bell with anybody? So basically there are three levels of scrutiny: strict scrutiny, intermediate scrutiny, rational basis review. We'll talk about the components in each one of those. These are both sort of referred to as heightened scrutiny, something other than rational basis review. And plaintiffs win when they get that standard, okay? Rational basis review, plaintiffs lose, with a few exceptions. Romer versus Evans being one of those exceptions. What gets you strict scrutiny or intermediate scrutiny? Okay, if you're assessed by classification or if there's a fundamental right involved. None of those do you get rational basis review. And the sort of the weakness of traditional rational basis review is the subject of a lot of scholarly commentary, okay? It's really, weak rational basis review is the standard that's applied in Plessy. Okay, that whole discussion about, well, we don't have to worry about, arbitrary use of race to order society because all laws are subject to a rule of reason. Okay, great, that really makes me feel better, right? So the first battle, and many would argue the most important battle, is over the level of scrutiny. Once you get heightened scrutiny, you're good to go as a plaintiff. And the second stage is application of the level of scrutiny, which, there's a certain uniformity, but it takes a lot of different forms. But is essentially a means-ends analysis. Okay? And again, this relationship between purpose and effect, this comes here, okay? The ends, that's the classification. Okay? Legislature says, I need to classify the basis of, cognitive ability in order to appropriately allocate these housing resources or whatever. Okay, that's Claiborne, City of Claiborne versus Claiborne Living Center. The means, it's not clear. It's either the purpose or the effect, depending on what case you're looking at. Okay, so the purpose would be essentially the state coming forward and saying, we passed this law in order to eliminate fraud in procuring food stamp benefits. Okay, the effect would be you are excluding X number of needy families because you have revised the law in this particular way. Okay, so whether one focuses on the purpose or the effect, I think potentially changes the outcome of the analysis. The court's been totally unclear about, the relationship between these two things. Okay, so we were talking about this to talk about the multiple paths through, just to kind of preview the multiple paths through the Proposition 8 equal protection analysis. Threshold issue, what does the threshold issue mean? It's important for what the work you guys will be doing.
Something like a first impression case?
It's not, actually. So issue of first impression...
Or just before you get to any other issue, you get to analyze that.
You have to, right, you have to, right, it's like crossing the threshold, right? You have to dispose of this issue prior to getting to the other issues, okay? So issue of first impression...
That's like a new issue.
...is a new issue before that court, okay? Threshold issue, I really feel like there's just one H there, right? You have to address it before you address other issues. And then dispositive issue, what is that?
Resolves the remaining issues.
Okay, and that doesn't necessarily have to be a threshold issue. It can or can't be. Threshold issues can be dispositive, but not all dispositive issues are threshold issues. So threshold issue in the Proposition 8 litigation, and well, what happened with the Obama administration and the Defense of Marriage Act? Is the Obama administration, is their role to defend it? Are they doing that? No. Okay, so this congressional group has come together to step in. Similarly, under Proposition 8, the governor of California is no longer defending it. And so you have the proponents of Proposition 8 coming together to step in. So there's a standing question in both cases, okay? That is a threshold issue and also a dispositive issue with the answer to the negative, right? But we're not going to talk about standing. I mean, I love talking about standing, but I don't think it's what you guys are here for this particular semester. But if you want to talk about that, we can do that. So assuming that both the congressional, it's BLAG, right? The Bipartisan Legal Advocacy Group. I love it, BLAG. Yeah, BLAG. And then I think it's just the proponents of Proposition 8. So both of those groups are going to have to demonstrate they actually have standing to continue the litigation on appeal. And assuming that they do, the court will next turn to potentially what level of scrutiny applies, right, to your Proposition 8. And so there are three issues there. I think the court should resolve it as a matter of facial gender discrimination subject to heightened scrutiny, which it would fail. People don't really buy this argument, but we could talk about why they do or they don't. The court could say it's sexual orientation discrimination, and then look at whether sexual orientation is a suspect or quasi-suspect class. And then finally, the court could conclude that the strict scrutiny applies because the law interferes with the fundamental right to marriage. And there are arguments on both sides of this, okay?
Did you say gender for strict scrutiny?
Intermediate.
Oh, okay.
Yeah. In California, gender receives strict scrutiny, but on the federal level, it receives intermediate scrutiny. What the difference is between intermediate scrutiny and strict scrutiny is questionable. There's some meaning to the distinction in the sense that the court considers it presumptively invalid in all cases to discriminate on the basis of race, gender, maybe sometimes okay. That's why it's quasi-suspect as opposed to suspect.
And then what was the third one?
Fundamental right.
Okay, thank you.
So one path is the court, well, this is a path, this is a path, this is a path.
Wouldn't there be a fourth of saying that it isn't a class, or it doesn't involve?
So
ideally that's what we
each.
don't want, but.
Well, it depends on your view on the issue, but.
But I mean, as far as the.
Okay, so you guys want to get down and dirty with this? All right. So first question, level of scrutiny, gender discrimination. If yes, heightened scrutiny, probably plaintiffs win. I probably shouldn't do this whole thing, but if no, then you might ask.
Okay.
First of all, is it sexual orientation discrimination? Is sexual orientation a suspect or quasi-suspect class? If yes, heightened scrutiny of some form, plaintiffs win. If it's not sexual orientation, because the law on its face doesn't discriminate on the basis of sexual orientation. Doesn't say anything about sexual orientation. To assume that marriage is about sexual orientation is perhaps optimistic. So if it's not sexual orientation discrimination, or sexual orientation is not a suspect or quasi-suspect class, then you are looking at fundamental right. If yes, then strict scrutiny, plaintiffs win. If no, then we're out of options for heightened scrutiny. Yeah.
Fundamental right, you're still under equal protection, not substantive due process?
Yeah, this is an interesting conversation. The way that I see it, under equal protection analysis, there are two prongs. There's the suspect, there's a classification prong, and then there's the fundamental right prong. These are two ways to achieve heightened scrutiny under the equal protection clause. And the fundamental right prong is different than a straight due process claim, because a straight due process claim can say that simply the government is interfering with this particular fundamental right. An equal protection due process claim says the government is interfering by using classifications of persons. So it's, whether you put it as a subset of due process or equal protection, kind of up to you. I see it as a subset of equal protection.
So then I have another question for you. But this is just for a facial challenge? Or would the same analysis apply to
Yeah.
whatever, I mean,
As
there's
applied.
like the as applied, yeah, is that what it is?
Well, so in equal protection jurisprudence, the distinction you're talking about is the difference between the existence of facial classifications versus discriminatory impact. And
That's just rational basis.
it depends. So essentially, the Equal Protection Clause only applies to laws that have facial classifications. Okay? It can apply with all the different levels of scrutiny, everything else, to cases where there's a discriminatory impact, but you have to make a special showing. Which is that you have to find evidence that the legislature enacted this with a discriminatory purpose. Which is pretty much impossible. Right, so this has been, and and if you can't do that, you just get general constitutional rational basis review, which wins you nothing, typically. So, this is a dead end in equal protection jurisprudence, and again, tons of scholarship about how, disturbing that is, given, what's the likelihood we're going to see explicit racial classifications in legislation? Zero. It's not going to happen anymore, right? And what's the likelihood that we're going to see explicit reference to discriminatory purpose in the legislative history? Pretty much zero. So there's kind of no future, in a sense, with this type of claim. So it would be bizarre if the court went down this path. I mean, I guess you could say there's no facial classification on the basis of sexual orientation, but it has a discriminatory impact. But there are facial classifications of persons in this law. If nothing else, it's gender. So I guess anything's possible, but I would be surprised if the court went in that direction. So there's another approach the court could take. It could avoid looking at the question of whether sexual orientation is a suspect class, whether this is gender discrimination, whether there's a fundamental right. Which is what the court did in Romer. And it went straight to rational basis review. Okay? And said, sort of two-part holding in Romer, there's no rational basis, and there's animus. Therefore, it fails rational. We know already, eyeballing this, it's going to fail rational basis review, so there's no need to go through this whole mess, right? Because the court, at the time Romer was decided, the court could not say that sexual orientation was a suspect classification because of Bauer versus Harvard being good precedent. Okay? So.
Can I ask one question right here?
Yeah.
So because it's, in my mind, because the legislature has not, what we're not questioning is the legislature's passing of a law, which would get lots and lots of deference. What we're questioning is the popular vote on an issue that people
Which
obviously
would get
have.
arguably
So
more
we're not-
deference.
That,
It's direct democracy.
true, but I feel like, I haven't read Romer recently, but the potential for animus is also a lot higher.
Ooh, that is a very anti-democratic, anti-common man sort of thing. Right, but so there's sort of the sentiment of the masses, right? Whereas our judges and legislators are totally above that. I'm joking, I'm just pulling your leg, but I understand what you're saying. But no, I think the court in general is very reluctant to find that there was impermissible animus on the part of either legislators or the populace. And Justice Scalia has this whole thing in his dissent to Romer about how the majority has sort of impugned the motives of other seemingly tolerant Coloradans, right? So it's an issue with both types of enactments, but it's something that the court's somewhat reluctant to find. Yeah.
Have any courts taken the same sex issue through the gender path? I feel like that, is that a hard argument to make?
So this might be your argument, and I would love to see it actually. The question is, and comes up in Plessy and then Brown and Loving, when is the Equal Protection Clause implicated? Okay, my reading of Plessy and Brown and Loving is that the Equal Protection Clause is implicated whenever you have facial classifications of persons, period. Right, so one of the arguments made by the state in Loving was, well, anti-miscegenation laws don't even provoke equal protection scrutiny because they treat blacks and whites the same. Members of neither group can intermarry, right? And the court rejected that. Essentially the same argument's being made with respect to gender. Okay, this is not gender discrimination because even though they're facial gender classifications, it's not, those classifications are not being used to treat men and women differently or to perpetuate sex stereotypes, which I also disagree with. Rather, both men and women are constrained in their ability to marry a partner of the same sex. I think that's exactly the argument the state made in Loving versus Virginia. But so the courts are kind of looking for is either something that subordinates women to men or subordinates men to women, or that advances sex stereotypes. And so as far as I know, and I try to kind of keep my finger on the pulse of all the same-sex marriage litigation at the federal and state level, but as far as I know, there's not an appellate court that has taken that route. The federal district court in the Proposition 8 case did see Proposition 8 as perpetuating sex role stereotypes. The sort of like viva la difference, formula of heterosexuality or what have you. Okay. So obviously I'm like raring to go to get into this problem, and then we'll probably get there. But this is kind of sets out for you, and I think it's a good background to have as we go into talking about the cases and then into the problem. This is kind of how the equal protection analysis works. These are the options you have in terms of working your way through the problem. And you're also going to want to probably have some sort of flagship case that, again, the court would draw a number of different cases in actually resolving this, but one way I thought about kind of working with you guys on this is sort of choose a case that you're going to use as your analog. So that could be Loving, that could be Claiborne, that could be Romer, that could be Plyler or something like that. Okay, any questions about that big picture? We're going to get a lot more detail with it, obviously, as we go on. That's a quick review of equal protection law and how it plays out here. Okay, so coming back to ethical judicial opinion writing, I've burned through all of our time. Take just 2 minutes and try to write down the thesis of the article. 3 to 5 sentences. Okay, and it's not easy, but just make your best effort. And just write it in an email to me. Again, I'm just kind of putting together a folder of all the random little things you guys write so that I can develop a portrait of you as a writer and a thinker. I mean, these authors take a position for sure. So what is that position? Okay, if you're really, anal, you can revise that later if you want to before sending it to me. But the point here is really just to get you thinking a little bit about your reflections on the article, okay? Some ideas. What's the point the authors are trying to make here? They're trying to advance an agenda. What is that agenda? Just go around this way.
I think generally what they're trying to say is that the actual structure, from the words chosen to formatting to everything that goes into judicial opinion, sends a message to the public about how ethical, reliable, thoughtful, credible the judge's opinion is. And then kind of determines whether people follow.
I like that idea that the power of the judiciary lies solely in words. It's a pretty powerful idea, right? And so there should be this sort of self-consciousness on the part of judicial actors on constantly maintaining their credibility with the public. And they do a nice job of exploring how, really all these things that you learn in legal writing about clarity of plain language, there's this ethical component and there's this democratic component to that. Thoughts, Bill?
I just sort of repeated that language you just mentioned, that the judiciary's power, their only power comes from words. So if those words aren't honest and fair, then the whole institution kind of lacks legitimacy.
I took out like the different ways of looking at judicial opinion writing, the pure versus impure. And
Yeah, next year, or when I do the model, I'm supposed to create a model syllabus for this class, I'm going to take out the whole impure thing because I just think it's so horrible. I would never want someone to write an impure opinion, but go ahead with that caveat.
and just how pure, there's like very strict traditional rules that judicial opinion should adhere to, ranging from like grammatical rules, like split infinitives and ending a sentence with a preposition, and
Which I love to do, actually, but that's neither here nor there. Go ahead.
and never referencing like culture, pop culture, whereas like impure opinions aren't as steadfast in those rules. And the article discussed like some judicial opinions that have like song lyrics in them or poetry or.
It makes me
or
sick to my
rap.
stomach. So what's their agenda with respect to that particular issue? What do you think? I mean, they describe both kinds and kind of suggest that they're both valid, but what do you think the author's agenda is there?
I mean, I think the author is in favor of pure opinions, but I think at the end of the day, since there's proponents for both schools of thought, as long as the opinion's still being clear with the law and being clear with like applying the facts to the law so that readers know what the holding is.
I don't know, if he's messing with IRAC, we may have a problem.
Go ahead. Yeah, this makes, I'm a purist, pretty hardcore, but I think it's interesting to explore, like, what could be the virtues of impure opinions? Can they be more accessible, possibly? It's an interesting question. Well,
Yeah, so when I went through it, it kind of reminded me of when I interned with Judge Lemon. I was kind of struggling with like each brief and then kind of decide which one is right and where should this order go. And she simply just said, start with what you think is right or wrong. Like you kind of almost have that ingrained a little bit. And so there is kind of like the legal analysis that almost takes you down one decision. And then her perspective almost was like backing into it. Where it's like you almost start with what you
with
think.
intuition.
Yeah, with your own intuition. Like don't lose sight of that. Like don't disregard what you know from a human perspective of what is right or what is wrong, and then kind of make sure that the law supports it, and that you're never doing anything like illegal or outside your bounds. But at the same time, it was like not a very checklist 22 step 1 through step 10 legal analysis to always get somewhere. It was like almost kind of start with your thoughts before you really start to analyze problems. So, and some of these I kind of felt for better or worse, they almost chose what they wanted and then figured out the way, like the illegal
Like Plessy?
Yeah, with Plessy, yeah. So like they chose where they wanted to go and then just kind of found the legal analysis roadmap on the way to get there.
Yeah. I'm very, and I would be really interested to hear Judge Lemon's view on this. I'm very suspicious of intuition. common sense, common knowledge, and kind of have this like zealous belief in the ability of formalism to save us all, but you know,
Right.
it's interesting.
I mean, for a 2-second explanation of like, what should I do with this? It's like, all right, well, like if I just keep that at a mindset, I could probably find the proper analysis or move through a little bit better instead of kind of trying to weigh like which brief or what motion sounded better, kind of letting the lawyers dictate what to look at. It was
that's right. I mean, because basically, you know, then you're letting money win.
Yeah.
You know, if you really just rely on sort of who has better argumentative skills, that typically tends to go with the party who's got more resources to throw at the lawyers. Alexis?
I kind of focused on the pure and impure too, as far as and seem to be advocating for somewhere in the middle, as wanting it to be understood, and that going to kind of public credibility, and that every part of what you do as a judge or in your writing plays out into how the public views you, and so thoughtful and deliberate.
Okay. Yeah. And let me boil this down a little bit, and then I want you to go ahead and jump in, Bill. But let's finish these sentences. The role of written judicial opinions is, therefore, written judicial opinions should be, go ahead with whatever you're going to say. It doesn't have to be responsive to that.
I guess with the pure and impure, I didn't sense an agenda either way so much with the author on that. I thought that he tried to point out risks within both.
Okay, so what are some of the risks of the excessively pure? You know, what can happen there? This is a lot of what you read in first year of law school.
Yeah, I mean, the excessively pure is, you know, it's so formulaic, it's wooden.
Which are, to me, great qualities, but what else?
Long-winded or repetitive.
Yeah, that's a treatise on the law, right? That whole idea. I mean, and when I went into my clerkship, that's what I thought I was supposed to be doing. It was not what I was supposed to be doing. Use of sources. What about the use of sources and pure opinions?
Overuse.
Okay.
So string cites where they're not necessary.
I thought if you didn't have a string cite, you didn't know what you were talking about.
That struck me as really interesting.
And the thing is, this is not a consensus view. I think this is a very progressive view that they present in this article, and I think there are a lot of courts, like the Vermont Supreme Court, that, you know, have adopted stylistic guides that go to some of these issues. But your judge may be very pure. And pure means different things to different people. I mean, to me, the idea of being very formal and formulaic is a positive. These things are negative, right, because they interfere with comprehension, right? They make the opinion less accessible. But excessive quotation and block quotes, you know, you want to work with the sources. You don't want to have the sources do the work for you. What about impure opinions? What are the risks there?
I had one more thought on impure opinions too. I was wondering also maybe if it differed slightly between like trial court decisions or like appellate courts, because I would think from the appellate court perspective, you might want to sort of show that like the full body of law that bears on this issue, kind of lay a foundation for people who are going to argue the issue in the future. Maybe more inclined to do that at the appellate level than the trial court level.
Not only inclined, what else is a factor there?
Required to.
Time. Okay. Trial court decisions are often produced under very, real time constraints, whereas appellate courts, it depends, but often have luxury of greater time. And it is their job to sort of be experts on the law. All right. Okay, so impure opinions.
Glib, the pop culture stuff, it seemed like some of the kind of demeaning.
Humor,
Yeah. Disrespectful. I mean, judges aren't
Which can
funny.
happen both ways. I mean,
Judges should try to be funny. They're not poets either. The rap was pretty funny.
yeah, the Eminem, I've read that one before. I thought she actually did a nice job with it.
Yeah.
Well, this guy.
I wouldn't want it to be my case.
Right? It makes you think that the judge is maybe a little self-involved, right, or something like that.
Yeah.
But okay, good. So I think that's a good point you guys are pushing me towards, which is to recognize that there are problems with each of these. That being said, you kind of know where my bias lies, and you know, we can talk more about that at some point if you want to. Okay, so the role of written judicial opinions is, we're sort of condensing what you guys have told me about the thesis here.
To provide clear rules of law.
To make decisions.
Okay, so there are multiple rules, right? Make decisions, resolve the conflict in front of them, provide. And this is so important. I mean, a lot of times you all will be looking, you know, to precedent and simply applying precedent, but sometimes you will be articulating new rules. And one of the, you know, wonderful things that my judge taught me was if you're crafting a rule, craft a rule for all time. Okay, I really think this is not just resolving this one case. You're presenting a rule of law that needs to be useful going forward, and that means two things. It has to be flexible enough to anticipate new situations, and it has to be concrete enough to actually be functional. Okay? What else? You guys talked about it over here. Supporting the credibility of the judiciary, which is not something I think people immediately think of, but I think is actually an important consideration. Also, this idea of reason forcing. So not only through the writing process are you going to come up with better reasoning yourself, but you are also justifying the outcome to the public. Okay, it's not just the decision is affirmed, the decision is reversed, right? There's an explanation of why that outcome. So given these different functions, what are some of the most fundamental characteristics we should see in written judicial opinions?
Accurate.
This encompasses a lot, and I think it's actually, this is, I think, the most important skill for law clerks to cultivate on a level above and beyond what you've been required to do in law school. Okay? Accuracy in what realms? Those are three main ones that are mentioned.
Facts.
Research, facts, and analysis. What does it mean to be accurate in research?
You present the precedents fairly and what they actually say rather than, you know, kind of falsely distinguishing something or.
Which parties do all the time. Actually, I shouldn't be too flip about that, but are you just relying on the research by the parties? No. Okay, that's really quite important. And I think it's, you know, the great thing about being a clerk is that you can do it right out of law school because the issue's already framed for you. The parties have made their arguments, but you need to resist the temptation to just defer to what they claim the law is and conduct independent research. So conduct accurate, thorough, independent research and then present the results of that research fairly. Even if your judge doesn't want to hear it, you still need to let your judge know about that, okay? There are diplomatic ways of doing that. Accuracy in the facts. I think this is something we have very little experience with as law students, what this means, okay? What are some things that feed into accuracy vis-a-vis facts?
What do you mean feed into?
Well, what both parties say.
And that's probably the least reliable source,
They're
right?
going to spin it to their
Yeah, so the parties' statement of facts is a tiny little, you know, it's like looking through a, what's it called?
Kaleidoscope?
No, the door and the hole in the door.
Keyhole.
No, people, when you're in the hotel and they have a little,
Yeah, people.
okay. And I'm not saying the parties are being deceptive, but they have a certain view of things based on the litigation, their you know, what happened at the trial level, their strategy, their agenda, etc. Okay, so where do you go for the facts?
Evidence, the record.
Okay, so there's just two different things, right? We don't look at evidence. We look at the record. We look at evidence in the record at the appellate level. What's the record? What's in the record?
That's a mystery.
Go ahead.
Exhibits?
Okay. Is there a standard? So not a specific description of what's in the record, but what is included in the record?
Transcripts.
Everything.
Or stuff.
Okay, so this is one of the things you need to figure out with your court.
You need to have like motions as well, testimony during the trial.
You could have everything, but you might not have everything. Whose obligation is it to assemble the record? This varies by court. Okay? So, for example, I mentioned the Vermont Supreme Court was very sort of justice-oriented. They would do whatever they had to do to reach the right answer, right? So it's incumbent upon the parties to assemble a sufficient record for appellate review, but if they left something out, we would just go call up the trial court and get it. 10th Circuit, if you don't include, and I don't know what the current local rules of 10th Circuit are, but you know, when I was there, if you didn't, the proponent, if the appellant didn't include something critical in the appendix, SOL. All right?
Can I ask just a real practical question
Yeah.
about that? Do you get this as like a box of documents?
It also depends on the court as to whether you're actually going to have that come and sit in your office with you, whether it's a box or binders, whether there's a record storage room. I mean, you guys know this. You could have a record that's an all-inclusive record with all the evidence, all the pleadings, all the transcripts. It could fill this room. Here's hoping that doesn't happen to you. It could be extremely voluminous, okay? So these are, I'm just, I guess, flagging for you these questions that, you know, the facts don't come from the parties, the facts come, I mean, that's a starting point. And hopefully you have local rules, like the 10th Circuit local rules require a record citation for every factual assertion. But they don't come from the parties. They come from the record, and the scope of the record depends, okay? And the proper place in the record depends. Whether it's incumbent upon the parties to provide this information, or whether you can go out and find it. It also depends. But what do I mean by the proper place in the record? So last time I taught this course, the problem we were working on was a case pending before the Colorado Supreme Court, and it had to do with Fourth Amendment, the automobile exception to the warrant requirement. And so what was the relevant record in that case? It was the trial court's decision whether to exclude a piece of evidence as a Fourth Amendment violation. Entire trial transcript? When did this happen? When was this decision issued?
Pre-trial?
Okay. Tell me about, how does this come about?
Your trial motion to exclude?
Okay, so there's a motion to exclude evidence. Go ahead.
I was going to say, for a criminal, wouldn't it be at the grand jury? Don't you want that?
I don't know. I really don't know the answer to that question. In this case, it was not before the grand jury. It was actually part of the pretrial motions practice. And so there are these factual questions about the information the police officers had, right, going into this. What's the relevant record there?
Their reports, their depositions.
What if they weren't introduced at that hearing? I don't know the answer to this question. This is a serious kind of question that you might have to think about. Because I could go into the trial transcript and find all sorts of support for whether, inevitable discovery or that there was some sort of probable cause, right? Is it the obligation of the government to present that at the hearing on the issue of whether there's a Fourth Amendment violation? So,
well, no, wouldn't it be about the evidence, whether the evidence gets in or not? And then the trial would be about the Fourth Amendment violation? Now this is all, and again, this is not my area of substantive expertise. I know it's up in the air in terms of whether excluding evidence, it's not mandatory to exclude evidence simply because it was acquired through a Fourth Amendment violation.
in the good old days, it was a little bit more reliable. And so the first hearing is this evidence going to be admitted? Because, purportedly there is a Fourth Amendment violation. And then you make the decision, excluded or admitted, and then you go to trial. Okay? The point being that the accuracy in facts means knowing how to work with the record, what part of the record is relevant, et cetera. And there are even, I'm being recorded, so I shouldn't say this, but there are appellate judges who are not tuned into these types of issues about record support. Okay, it's something that's very, very important to your role as a law clerk. Okay. Analysis, accuracy and analysis. What does that mean?
The application as well. I mean, what you put under there, grammar, whatever else, making sure you.
So that I would put that under clarity in general, which is ideas of writing clear, direct, plain language, right? Having structure, having organization, those more stylistic qualities. Accuracy and analysis, I think, actually means having a logical underpinning for your analysis. And that's one of the critiques one could lodge against Plessy versus Ferguson. Go ahead, what's your comment?
Yeah, I was just going to say, with Plessy, we see there's just like this big lie at the center of the analysis, where it's like separate but equal, and they pretend like they have no idea that there's any difference between the races, and it's all equal, and
it was black people just feeling that way about it.
Yeah, the black people were making that up, and
where does the idea of inferiority and superiority really come from? Does it emanate from the person being discriminated against, or does it emanate from
and the denial that there's no discrimination at all, which they know is false, and then Harlan in his dissent, sort of comes back to that again and again with like this, you're just not being honest with, there's this giant lie at the center of your analysis. And then, I mean, if we go to...
So that's a failure of logic, is it a failure of ethics?
I think it's both.
Okay.
I think that failure of ethics, because you're kind of, you're sort of consciously lying about why you're coming to the decision. And it's
Were they consciously lying?
I don't know. I mean, Bowers is the same thing, where it's these old guys with this like repulsion at the center of their thought, and then everything emanates from that.
So what's a general problem? So this is the question that drives me, because we know that there was a certain mindset about race equality in the United States at the time that Plessy was decided, and that's going to affect judges just the same as it affects everybody else. And maybe you disagree with that, but. What question could they have asked themselves to overcome their own contemporary prejudices and to force a more reasonable, logical, just, ethical decision? Right? What is on a categorical level, what was the failure in Plessy, the failure in Bowers?
I think it's a really baseline, like, golden rule argument. Like, how would I feel if I was in this situation, if the roles were reversed? And, like, not that you have to always go there in your mind, but I think there is a real lack of insight into,
man. No, I mean, I love this. No, I love this. I think this is actually really profound, because what would prevent someone from applying the golden rule? What if I were in that person's shoes? Well, that'll never happen because
I'm better than that.
I'm better than that, right?
Yeah.
I'm white and I'm innately superior. What kind of social systems and thought structures prevent application of the golden rule?
Thinking that your view is morally superior.
Mm-hmm.
Or
like a superiority complex?
Or just like thinking that they know the difference between right and wrong and what they're saying is right.
Certainty. Excessive certainty.
It seems to be like a preservation almost of like a social hierarchy.
I think
especially when they got biblical.
Hierarchy is not spelled the way that you think it is spelled. I always have to remember that. If you live in a hierarchical society and you accept the hierarchy, to say to person A, golden rule, you should think about what it's like to be person B. It's inaccessible. It's irrelevant and inaccessible, right? I mean, this assumes a sort of a really profound equality that is not perhaps embraced by all.
I agree, except that we're in the context of equal protection analysis in both of them, so isn't that the whole point?
I think it is the point. I think it's interesting how absent that notion is, right? I keep trying to find, I feel like I read this piece by Derrida once that talked about infinite regard for the other as being kind of the underpinning of justice. And I have researched, I've really tried to find this exact language and I haven't found it. So I'm just going to pretend that it's true and attribute it to him. But this sort of idea of the opposite of sort of hierarchy and entitlement. Right, which is to put oneself in the shoes of the other person, the person who's on the other side of whatever law happens to be. Right?
But I mean,
a little bit of that happens in this opinion.
I think that if you, not arguing for the other side, but if you think that if you don't even recognize that the other side exists, or then this can't really apply, I guess kind of like what you said, that you would never see it that way, or, because I think in retrospect it's always really easy to say, like, oh, I can't believe they would think that or whatever, but...
Right, what are we doing right now?
But it has to be, like, with your kind of blinders in your society that you have right now.
I, sort of compare it to, like, your fork standing up at the table and saying, I deserve equal rights. And how would you respond to that, right? It's outside of...
Property at that point.
What?
It's like property.
Well...
It's like, I was thinking of my computer being like, treat me better.
Yeah.
No, you're going the right guy.
Yeah. I mean, and that's the other kind of side of this question. What are our prejudices now that in 100 years will be seen as despicable? Is there some universal principle that we can identify? I think part of it, and can we tie that into a standard? One of the standards articulated, for example, in the article about ethical judicial opinion writing. Even if you don't have a rule of precedent, you might at least have a rule of logic. But what kind of rule was the majority applying here? What was the court using for guidance?
In Plessy?
Yes, in Plessy.
Well, at one point the majority pointed to the fact that if we desegregated railroads, schools are still segregated and nobody's saying anything about that.
Okay.
Or just like other aspects of society are segregated and nobody's raising that.
So this idea that if it's traditional, if it's the status quo, that means it's right. That's very uncritical, right? And it's especially out of place with equal protection jurisprudence, which is supposed to be prospective, right, as opposed to due process. Yeah.
Well, I was thinking about in the Hardwick case, their kind of underpinning is that, it's the tradition, it's the status quo, but they also cite kind of morality and more generally, what they say, like never in whatever, I don't remember, something about not in modern times, or the millennia of the crime against nature.
So that's sort of that Judeo-Christian heritage idea, maybe.
Yeah.
But are these things problematic in and of themselves, or is it problematic that the judges consider themselves the arbiters of these values, right? I mean, also ideas like common sense and common knowledge. Should judges? Do judges live? Do justices of the United States Supreme Court live in the same world that the rest of us live in, socially?
No.
Yeah.
Okay, so...
Like one of the justices admitted, wasn't it, or arguments that he had never met a homosexual person?
Yeah.
Who was that?
It was that was in a memoir, I believe, by one of the justices' law clerks.
Oh, okay.
Bill, you look like you know the answer to this. No?
No,
Okay.
in that book, The Nine that Tubin did, he
Yeah.
talked a little bit about some
Okay.
of the justices who had admitted that. Some of the clerks were gay at the time, and it's like they had no clue.
Mm-hmm. Right.
Listen to
Yeah.
the quote, yes, it was good.
I've never met you. Oh, funny.
Yes,
In fact, you have.
Yes, you have.
Like in criminal procedure, we talked about the common sense, common knowledge in the consent search cases, the bus cases, when it's like, how often do the Supreme Court justices ride a gray bus that they can say that someone would feel comfortable saying, like, yeah, you can search my bag.
Right. So if we're looking for a transcendent principle that could help us identify contemporary prejudices today, and that is something maybe we could have asked the justices on the Plessy Court to ask themselves, maybe it's that these types of knowledge, they're neither facts based on the record, nor are they rules of law or rules of logic. And so maybe it's something about this type of knowledge that is problematic, and that it's, potentially unethical to draw on that type of knowledge because there's no accountability to the public. Yeah.
It's like philosophically, it's hard to go too far with that though, because it's such a practical way of thinking. It's like you have to believe in all the tangible things around us are true, and that there's not, these kind of completely different truths for different people, so that facts are completely meaningless in the end. It's like you have to be you have to agree to all of these sort of common knowledge principles to take part in the legal system at all. So then how do you go to a certain distance with that and then stop it at some point?
Well, and doesn't
that's let me get you. Yeah. Go ahead.
Well, doesn't it also inform your interpretation of, if it's to the record or if you're interpreting something, your interpretation is informed by whatever common knowledge or whatever knowledge you have in your contemporary mind.
I had no idea I'd have all these post-structuralists in the classes. Messing with my mojo. I think that's right. I think that we should get out of here. That you could still identify points on a spectrum as to what is really unexamined common knowledge versus conventions that we've actually tacitly agreed to apply. Right? I'm thinking like Wittgenstein or something here. It's been a while. But can we at least have enough clarity to identify the patterns of mistaken reasoning that permeate the worst decisions of the United States Supreme Court and other courts? Great conversation. We need to get out of here. I wouldn't even prepare for Wednesday, Alexis. Let's just get everybody going on Monday with their articles, and we're going to talk more about Plessy and then about Bowers on Wednesday. Great discussion.
So don't do it.
I'm really sorry.
No, I'm really early. Okay. I've been doing this monster problem with the students, and I involved all the boards. So I've got to do all of it before I come to class in half an hour. So
brilliant.
And it's just enough time for me to go out here. So I'm sorry.
No, you have no need.
Normally I won't need to get here early.
You want to give them individual attention as what you want.
Huh? Good.
I'm in the hallway.
Tell them all this.
That's right.
Exactly. So you're
visiting.
and you have somebody. You have David Stevens.
Yes, that's what this group is.
Okay.
And then I took over one of my sections, so I actually lost a section, kept a section, and picked up a different section.
Keeps you on your toes, huh?
Yeah, I'm doing two different syllabi right now. Like one group is sort of catching up to how I do it, and then one group is sort of going forward. So
that would be a little much for me.
yeah, it's kind of stinks. Stinks for the students too.
Yeah, no, it's tough.
This is nice. I hope we have enough people that can actually get a choice.
Yeah, are you getting the sense that you have 11 and a half?